President Cyril Ramaphosa suffered a major legal blow when the High Court declared that the president's suspension of Public Protector Busisiwe Mkhwebane was unlawful. Please kindly subscribe, like and share as we into the details. Following Mkhwebane's legal appeal to her suspension, which claimed it was politically motivated and intended to hamper her investigations, the ruling was made public on July 14, 2024. The court determined that Ramaphosa's suspension of Mkhwebane in June 2022 was procedurally unjust as it was imposed without a good reason. Judge Thabo Makona said that the president's actions were motivated by a desire to avoid being scrutinized in the wake of accusations of corruption that Mkhwebane was looking into. The suspension of Mkhwebane was sharply criticized by opposition parties and civic society, who saw it as an effort to erode the Public Protector's office's independence. Mkhwebane praised the court's ruling, highlighting the success for legality and accountability. She declared her will to keeping influential people responsible. Official comments on the decision have not yet been made by President Ramaphosa. After this ruling, legal experts expect Mkhwebane to be reinstated and that her continuing investigations may be strengthened. The High Court's decision highlights the judiciary's responsibility to protect South Africa's democratic values and the division of powers. The continuous conflicts between independent monitoring bodies and the executive branch are brought to light. The focus of attention is still on Ramaphosa's next moves in handling this legal and political issue as the nation processes the verdict's consequences. Once again, considered as documented evidence or is likely to be genuine evidence, he said, noting that he had no idea what the witness might choose to tell the judge. And in that sense, it is important to understand that the kind of evidence comes into the category of documentary evidence, or that it may be genuine evidence, but only if there is a chance that the original text or evidence has been tampered with, altered, or manipulated. Therefore, I will decide that this will be genuine evidence in the interim, and the whole reasoning will be included in the main decision. The court may review the decision made during the interlocutory phase, just as I have done in the past with other types of interlocutory decisions, when everything has been viewed and considered. Therefore, in this case, after hearing the real evidence and seeing precisely what this witness is going to testify about, it will be taken into consideration and made obvious what it is when we render a decision at the end of the day. Later that day, Mkhwebane again objected to the witness testifying about the data transmissions, but MIPA decided the witness may continue with his testimony. She said that he objected because, in contrast to what the state had first told the court, it was obvious that the witness was presenting the data packets for verification of their veracity. She claimed that Mkhwebane made the second interlocutory ex tempore verdict and rejected Mkhwebane's objection after hearing further arguments on the objects. According to MIPA, in December 2020, Mkhwebane filed an application against Mkhwebane requesting that he consider recusing himself. Following the arguments, Mkhwebane provided a written ruling that included a discussion of the challenged data's acceptability. Additionally, Mkhwebane filed a discharge request under Section 174 of the Criminal Procedure Act 51 of 1977. He brought up a number of concerns, one of which was that Mkhwebane never came to a definitive conclusion on the data message's acceptability. Mkhwebane rejected the application and upheld his earlier interlocutory ruling. At the trial's conclusion in August 2023, MIPA said that Mkhwebane had presented his closing arguments, which called for an acquittal and addressed Mkhwebane's failure to provide his final ruling on the admissibility of the data evidence before the state case was closed. Thus, the learned judge was informed twice that he had not reached a final decision about the inclusion of the challenged data messages, just before he wrote his ruling in which he made incorrect comments that are the focus of this complaint. This was in addition to the 3 times he was asked to do so during the trial, which led to the 3 interrogations he had, MIPA stated. Mkhwebane also paid attention to his earlier rulings, in which he explicitly declared that he would review the provisional admission of the data messages and provide justification when he rendered his final decision. She said that Mkhwebane had made up information about his non-existent verdict in order to provide a foundation for using the similarly non-existent data proof to declare Mkhwebane guilty. Has, in the meanwhile, filed an urgent appeal with the Constitutional Court about the false statements in question.